They flipped a light switch and set off an explosion of cockroaches. A pair of home buyers thought this was sufficient grounds for getting out of their contract. The court in Weintraub versus Krobatsch considered whether a house full of roaches justified a change from the old rule of caveat emptor. Natalie Weintraub owned and occupied a 6-year-old townhouse. She listed it for sale. Donald and Estella Krobatsch saw the house and liked it. They agreed to buy the property for $42,500. The contract of sale stated that they had inspected the property and were fully satisfied with its physical condition, and that the seller had made no representations and assumed no responsibility for the present and future condition of the property. The Krobatsches paid a deposit of $4,250 to be held in escrow by the broker. Weintraub had the house fumigated. The Krobatsches were all set to buy the place even after a small fire caused some damage to it. Shortly before the closing date, the Krobatsches paid their first nighttime visit to the house. When they turned on the lights, they were horrified to see a horde of roaches scattering in all directions and up the walls and drapes. The next day, they had their attorney write Weintraub announcing that the house was evidently unfit for human habitation and rescinding the contract. An exterminator informed the Krobatsches that he could eliminate the roaches with a 3-week treatment plan that would include removing the carpets. Weintraub sued, seeking the deposit as damages for breach of contract. The trial court dismissed the case without a trial. It awarded Weintraub the $4,250 that was in escrow. The appellate division held that the Krobatsches were in default, and they were thus responsible for paying both the deposit and the broker's commission. The Krobatsches appealed to the New Jersey Supreme Court, arguing that the court should have heard their claim for fraudulent concealment or non-disclosure by the seller.